I want to welcome everyone to today's Beverly Hills Bar Association webinar. My name is Tomas Ortiz. I am counsel with Zuber Lawler here in Los Angeles. I'm also the chair of the cannabis section for the BHBA. This will be the first of a handful of talks we'll have this calendar year on cannabis and the law. Today I have with me Ryan Fingerhut. Ryan is an attorney and a partner with Global Go LLC. Ryan has devoted himself full-time to the cannabis industry since 2014. He focuses on cannabis consulting, licensing, and compliance, including the transfer of licenses and the ownership change process. He's participated directly in the management of several cannabis businesses before becoming a full-time cannabis consultant, and is an expert in cannabis license valuation and risk issues. Hi, Ryan, how are you?
Great, nice to be here, Thomas.
Good. So I felt compelled because it is the first meeting of the year for the cannabis section to spend a little bit of time early on, just kind of talking about where we're at. It's been over 5 years since the Adult Use of Marijuana Act was voted into law, legalizing recreational use for those over 21 in California. It's been over 4 years since Senate Bill 94 was signed, integrating state medical marijuana regulations and adult use regulations, and creating the Medicinal and Adult Use Cannabis Regulation and Safety Act. And I won't even try to pronounce the acronym on that. So I think it's a good time to ask, where are we on cannabis? And if we can move to the third slide, I'd appreciate it. Great. Moving over to the fourth.
I found this on the web.
Sorry about that. There still exists the tension between federal prohibition and state legalization. Cannabis remains a Schedule I controlled substance under the Controlled Substance Act. It is federally prohibited. There have been attempts to introduce legislation to remove cannabis from Schedule I. The Marijuana Justice Act, introduced by Senator Booker back in 2019, Marijuana Freedom and Opportunity Act by Senator Schumer, I think also in 2019. Both of those are in committee, as they say. And there's also the Marijuana Opportunity Reinvestment and Expungement Act, which was the MORE Act. And that was introduced back in 2019, passed the House in December of 2020, wound up in Senate and died in committee, although it was reintroduced in May of 2021. There have been attempts to use the courts to deschedule cannabis, Washington v. Barr lawsuit in 2020, Sicily v. DEA, which was dismissed last year. So unfortunately, we are where we're at with federal prohibition, which complicates things. Proceeds from cannabis-related activities are subject to anti-money laundering laws, BSA, Bank Secrecy Act, and Money Laundering Control Act. And that rolls into what has been, and I think continues to be, a serious challenge in the cannabis sector, and one that we'll likely touch on later today and in the months to come at other meetings, and that is banking. Banking has been a challenge. Illegality at the federal level has made it impossible for legitimate cannabis and cannabis-related businesses to use federally chartered and insured banks for depository financing and other banking services. Banks don't want to risk those charters and insurance, nor do they want to take the extra burden of compliance with federal guidance or risk falling afoul of the BSA and anti-money laundering laws. This has narrowed banking opportunities for cannabis businesses to state chartered banks and credit unions or other less favorable financial situations or solutions. This impacts day-to-day operation, transferring of funds, payroll, etc., which is one of the frustrating elements of this federal versus state tension, because state-wise, things are getting better. There has been a steady increase of legalization across states. States are coming online every month. There's been an increase with regards to medical, both full and limited, also recreational. There is a wrinkle, and that is that there's no uniformity across states. As they say, some states are better than others. But it also is the same wrinkle that's shared within states, because there's not necessarily a uniformity or consistency among states and municipalities and counties. So I would say, since I'm talking to a bar association, we're all lawyers, that makes for good business because it means people will hire us to figure all this stuff out. In California, we've got the Department of Cannabis Controls, DCC, which regulates cannabis. But as I said, there remains a localized difference in the regulation of the industry, which is what we will be talking about today in part. So if I could have the next slide. We are going back to a federal prohibition. We are chipping away at it. There's the Rohrabacher-Farr Amendment, which was introduced back in 2001 and basically prohibits the Justice Department from spending funds to interfere with the implementation of state medical cannabis laws. That doesn't change the legal status of cannabis and requires renewal every year, and it has been renewed. And the last renewal was by President Biden in connection with the omnibus spending bill, and that's effective through September of 2022. The Safe Banking Act has had many lives, and it was first introduced back in 2019. It's set to ensure banking services at the federal level by removing the legal and regulatory risks and that we just talked about. That makes it so difficult for federal banks, federal chartered banks, to provide services to cannabis businesses. It's been passed by the House as a standalone 3 times, but never got a vote in the Senate. It has since been attached to larger legalization legislation. Currently, it's included and passed as part of the Competes Act, which passed through the House in February and now sits with the Senate. I've done this type of update several times over the last couple of years, and I always end my Safe Banking Act review with it now sits with the Senate, regardless of how or in which iteration the Safe Banking Act is. It's always sitting. It reminds me of the Schoolhouse Rock. I'm only a bill cartoon. It's just sitting there waiting for somebody to pay attention to it. There's also the Claim Act, and that it proposes to do for insurance services what the Safe Banking Act does for banking, providing safe harbor from penalties and adverse actions for insurance companies providing services to cannabis-related businesses. And that also was introduced in 2019 and was recently reintroduced last year in March and is now been referred to the Committee on Banking, Housing, and Urban Affairs, where it now sits. It would be remiss of me not to include in this around the world in 10 days review of cannabis the note that as the industry grows, it has been difficult for businesses, not only dealing with the issues we just discussed, but also the cost of business has become particularly difficult. And this is especially true in California, where the tax and cost crunch has really made doing business, in some cases, completely untenable. And I hope that in some upcoming meeting or webinar dates, we might be able to touch on those that subject with a little more detail. But so let's turn and take a deeper dive and focus on the topic of today's meeting, which is investment in cannabis. And in discussing investment in cannabis, it makes sense to look at hurdles investors and lenders face as they enter the sector. Ryan has worked on legal memorandum and transactions regarding lending and investing in cannabis sector, and will walk us through the process or life cycle of a deal with special attention to regulatory hurdles, ownership, and licensing issues. Ryan, why don't you get started where you feel comfortable doing so?
Great. Thank you, Tomas.
Yeah.
Can I have the next slide, please? So when looking at the collateralization of an asset and investment into the cannabis space, the first thing to really focus on is what is allowed and what isn't, and how does that affect the entire transaction. So MCRSA, as it's referred to by its acronym, is the California law that legalized cannabis. MCRSA, though, did not legalize cannabis necessarily in the way that a lot of laymen think about it. It did legalize it for all individuals within the state for possession under certain personal limits. It did not legalize commercial cannabis activities, except for persons who have been licensed by the DCC now and by individuals who have been approved by the state to operate in accordance and compliance with the full laws and regulations that are applicable. That has a very distinct consequence. All cannabis inventory is illegal for non-licensed parties. I've seen several situations where people thought that MCRSA greatly reduced risk and factors here, or that they could operate with a license, but sort of not in compliance with the regulations. That is not true. If you are operating either without a license, or if you're operating a license in complete disregard for the regulations, you are still facing the same felony, jail time, all of the other serious criminal potential situations that can occur pre-MCRSA. So that's definitely something that everybody needs to keep in mind. Now, it's worth stating, I said compliance with the regulations. People fall out of compliance with the regulations on a fairly regular basis, and it's dealt with as a civil matter. However, what kind of defines that is if you are operating in good faith, or as long as you're not operating with reckless disregard for the regulations, generally that's how the DCC will regard it. If, however, they come in and they see that you're, doing something as has occurred in California, people are selling product out the back door without registering it, doing things that are clearly in violation, and that nobody could make a colorable argument that you are trying to comply with the regulations. That's when they will refer it to law enforcement, and law enforcement will prosecute. So it's worth noting that when you get involved with the cannabis industry, even as an investor, depending on what sort of role control you're playing over the operation, you could be looking at some significant personal criminal liability. And even if you yourself aren't involved in any way, shape, or form with that, if the licensee is doing that, and you're unaware, you could lose, your investment. You could lose all the assets and collateral that you tied your loans to, or other types of investments to, based off of their malfeasance. Next slide, please. Okay, so the next thing to understand when it comes to the requirements around the life process of investing into the cannabis space, and for attorneys, the due diligence and structuring of such transactions, is that you are dealing with dual masters. You're dealing with both a state license and, in almost all cases that I'm aware of, a municipal license. There are one or two municipalities that don't really have much of a license, but they are by far the outlier. Generally speaking, anything that in transaction you do, any collateralization, you need to be reviewing all requirements at both the state level and at the municipal level. And the municipal level can be quite an issue, especially in California. I put in here an example of one of the more challenging, which is out of San Francisco. In San Francisco, you cannot transfer more than 50% of the equity in a license without voiding that license. And that's in the aggregate. So if you come across, if you come across a license and you want to collateralize that license, and 20% or 30% of that license has shifted ownership, the equity of that license has shifted ownership over the course of time, you can be looking at an asset that at most you can collateralize 20% of. So that's definitely something worth considering. You need to always be thinking in your head, I don't just need to deal with the state laws and regulations, I also need to deal with whatever municipal or county laws or regulations are applicable here. And in case you all are wondering how to determine if I'm dealing with a municipal or county regulatory authority, generally speaking, you can look towards who is in charge of the zoning and building codes for that particular property. In almost all cases I'm aware of, it's going to be the same party, whether it be a municipality or a county, though I will caution you, if you are dealing with cultivation, manufacturing facilities, or any facility in a smaller town, oftentimes they will farm this out to their county fire marshal, county building, county planning department. You should still always go through whichever entity technically has jurisdiction, and not necessarily just look at the entity that's actually exercising that jurisdiction. Next slide, please. Okay, so the first part of any of these types of transactions, once you sort of understand what you're walking into, is to understand the due diligence process. You need to understand what the value of the asset is before you can use it as collateral, before you can, size up your investment in it. And so looking at the state license due diligence, there's a few places that you should look. So first, license infractions, they are cumulative. 3, 4, 5 license infractions in the previous years before you took over, that will be taken into account when deciding the fines and possible suspensions or even license revocation at the state level. They do generally give some consideration to a change of ownership when it comes to the mens rea of the infraction, when they're considering whether or not they have a bad faith actor here. Somebody's been corrected on something several times and is still doing it. However, at the end of the day, under the code, it is still an aggregate that they look at when deciding what the penalties are for any given infraction. So if you're taking over or collateralizing against a license that already has several infractions, that should be impacting the value in your head or your client's head as to that asset for purposes of collateralization or investment. Another thing that we oftentimes see, especially in older licenses that predate 2018 and came from the time before MCRSA, when we sort of had an unregulated medical market, ownership transfers that don't match state records. I've seen a couple of transactions where basically by entering into the transaction, they ended up triggering a number of violations on the license, because what ended up happening was the corporate paperwork being put forward from the deal did not match what the state records were. So you always need to make sure that what you understand, what the other side of the table is putting forward as the current structure that you're buying into or investing in or using as collateral matches what the state records have. Or if you were to move forward, either with a disclosure requirement through a direct investment, or if you secure your investment against that asset, and then later on go to perfect that security, seize the asset, you can end up severely damaging at least the license that you're allowed to operate under by moving forward with that, unless you make sure that already the state has a clear, solid, and accurate picture of the ownership of that license and the equity and finances behind that license. So finally, and this might be a little bit of overkill, but we always suggest if you're going to make a major investment into this asset, or if you're going to tie a major investment to the asset, that you should probably have somebody do a compliance walkthrough and review the traceability system, audit that to make sure that you don't have any violations that are sitting out there ready to destroy this license and this asset, which is by far usually the main asset of the entity, barring the inventory. And the inventory, of course, you can only deal with if you have that license. It's worth noting, actually, that one of the reasons that many banks stay out of the cannabis industry is because the credit unions who are working with cannabis entities usually do this themselves annually, or at least the beginning of the account, in order to make sure that they're not tying themselves to a bad actor who might get them caught up in unlicensed money laundering by working with cannabis. Another thing, and this is a bit unique to California, but California of course has its very famous devotion or concern towards employment. So there's a few things that are in there, and there are a few states that are like this, which is that a labor peace agreement is required for any entity over a certain threshold. In California, it's 20 employees. So you need to verify if the entity that your client's investing in is either has gone above that 20 employees, or has entered into an LPA already. And then you should probably review that LPA to see what sort of effect it might have on the valuation of that asset. Second, and this is pretty unique to California, but California's Employment Development Department, they keep a record, of course, of any employee complaints or actions against the licensed entity. That is taken in consideration during their license renewal process. So if you have somebody with a large amount of infractions against them, employee infractions against them with the EDD department, that should be considered significantly when evaluating this asset, as the license might not be renewed at the end of the year. So environmental, this is especially important for manufacturing cultivation facilities. First, if you see that there are major infractions here, this is actually where we see the biggest fines, fines in the tens of thousands, hundreds of thousands of dollars. Famously, a few years ago, the DCC went into the Humboldt County area and cracked down on a number of illegal growers. Their fining process was not what they considered to be sufficient. So they actually brought the environmental department with them. The fines from the environmental department far exceeded what was brought by the DCC. So people should be aware of that. And probably if you're investing in a major cultivation or manufacturing facility, there should be some consideration and analysis as to whether or not there's any liability there hanging around the asset. Finally, if you're dealing with a provisional license, right now, provisional licenses for cultivation and to a lesser extent manufacturing are taking around a year to get through. And the main issue there is the California Environmental Quality Act, CEQA. So the way it's currently working, you are allowed to get a provisional license once you submitted a complete application for CEQA compliance. You're not allowed to get the annual license until you've been approved. There's been a very long drag there. Provisional licenses go away at the end of this month. As far as the ability to apply, they won't be renewed beyond next year. So if you have a provisional license and you're trying to value that, especially if we're talking about a cultivation or manufacturing facility, you should be looking into where they are with their CEQA compliance, where they are with their CEQA application, to make sure that that provisional license will successfully translate into an annual license by the termination date. Finally, and this is a slightly lesser extent, but it's always worth noting, associated licenses. So California has something that's rather unique in that distribution licenses are necessary to move cannabis from one license to another. This has sort of an extremely hyper technical definition by the DCC, which is that if you have a co-located manufacturing facility and cultivation center, they might be separated by a wall with a door in between the two spaces. You still need a distribution license to be involved to move the cannabis from one room to the other for full processing, even if testing won't be done because all of the cannabis is being grown to be produced into a manufactured product. So it's the manufactured product itself that will be tested. This has largely been known by most operators. And so most operators do get the right licenses in place to be able to function fully. But if you are collateralizing against an asset with the understanding that this is a fully functional facility, for instance, a manufacturing cultivation center, you need to make sure that the distribution license or any other licenses that are necessary for the business model that your client is investing in are included, either in that investment or as something that the asset's being put against, or you might end up in a situation where you have a license or an asset that isn't really workable. It's not really operational without a ton more work. Next slide, please. Okay, so then looking at the local license, most of what I previously said actually isn't really as applicable here. Outside of licensing infractions, you should still review the local record for any licensing infractions, though generally speaking, that is a mirror image of what the state, but not always. However, there's a few issues here that directly affect the valuation, and people really should be aware of it. The first is what's I generally am referring to as community benefit. So one of the things that's been pretty common in the California space, frankly, in a lot of different areas across the country, unless the state law specifically bans it, is that local communities require more than just whatever the local tax is for businesses. They oftentimes do have a special excise tax on cannabis. However, for various reasons, they try to keep that low, including that some communities actually require that you go to vote a referendum to raise new taxes. So instead, cities sometimes try to get around that, and that can create hidden liabilities on the asset. The first main way that they do it is a development agreement, which for those who aren't aware, it's an agreement that certain communities enter into. Basically, it's a private agreement between two parties, contractual. It allows cities to get around certain requirements of the law and certain political issues that they might have by raising taxes in a jurisdiction that doesn't like taxes, by basically entering into a private agreement as a prerequisite for starting a cannabis business in the area. There will be hidden fees there almost always, if not hidden requirements around funding and things of that nature for police officers or schools or repair of roads, or some of the more common ones are putting in stoplights and things of that nature that can very quickly raise the liability and bills, and really the debts of the company, and turn a very profitable company into a very unprofitable company. Even beyond that, beyond the development agreement, sometimes for lack of a better term, it's a little bit pay to play when it comes to these local municipal applications. When they're competitive, they will grade and award points based off of a business's pledge in their application to give certain benefits to the community. And if those benefits aren't given and you have an unreasonable community, you can end up in a situation where the community pulls your local license by basically saying that we determine that you got this license over competitors based on your pledges. If you're not going to keep that pledge, then we're going to go with somebody else. So it's always good to be aware of not just the tax liabilities when valuing an asset, but also what other private agreements they might have with the community, or whether formal and development agreement or simply through the application process they've made, as that's going to significantly affect the value of the asset. It's also worth noting that you should look at local regulations. Now, there's actually two ways that I say to look at this. The first is if we're talking about a retail establishment, these are basically localized monopolies for the most part. There are very few municipalities out there that will just openly license retail. Normally, they severely limit the number, whether that be directly through only having 5 licenses in the area, or whether that be through zoning requirements and setback requirements that effectively mean that there's only a certain number of areas where these businesses can be located without violating the code. So you really need to look at that, and especially be cognizant of any potential changes that are coming up. As a good, for instance, we had a client who asked us to value a business that they were looking at investing in. This business, by the numbers, had very impressive profits. However, when we were looking through the local political situation, we found that they were just in the process of doubling the number of the dispensaries in the area, which meant that just valuing off of its past performance wasn't necessarily going to be reflective of the value of the business going forward. And negotiations were had based off of that fact. So whenever you look at a retail establishment, you should always be considering whether or not it's got a localized monopoly that's deriving a lot of its value from, and whether or not that localized monopoly can be considered something that might be going away soon. Second is going to be a lot of local regulations that go added security, added requirements on employees, things like that. In retail, it's not as big of a deal because these assets are localized monopolies. The only real competitors you have are the people who also have to meet that. However, when it comes to the wholesale side of the business, cultivation, manufacturing, this is going to directly impact profitability of the business, as it's going to impact costs. And if you've got a municipality that is significantly more expensive to do business in than your competitors. Because remember, with cultivation and manufacturing, your customer base is the entire state. You know, you should take that into consideration, because you might have a company that, you know, is well funded, newly opened. But when you really get into what the net is going to be for that company, it's actually severely depressed because of local regulations. Finally, worth noting is political shifts. We've had ourselves in the past year 2 major political shifts with clients that we were working on, and it's impacted very much so the profitability of businesses. One example is in Yolo County in Northern California. They've taken a very anti-cannabis sort of bent, politically speaking, and so you actually see a number of companies, cannabis companies, fleeing Yolo County, including one of our major clients, because it's death by 1,000 cuts. Everything takes a very long time. The regulators are extremely unfriendly. They keep putting more and more regulations in place that make it more difficult to do business, and we believe that that's intentional. They don't want these cannabis businesses in their location anymore, and so they're doing everything they can to convince people to leave. Second is the city of Palm Springs. They had a very major, I don't want to say political upheaval, but they had a number of residents organize and come to a number of city meetings complaining about odor control issues and other things that were occurring in the city. And so what we've seen is a number of new regulations, new processes come into place. So everybody who's already licensed in that city has been grandfathered in, but anybody who's entering into the space or who wishes to expand beyond their current footprint in Palm Springs are facing a much more time-consuming and expensive process to do so. Palm Springs, unlike Yolo County, isn't trying to get people to leave, but they have put in a lot more requirements that make it much more difficult to do business there if you're a new entrant or if you're looking to expand.
Brian, if I could add in, similar, it's a hemp client, not a cannabis client, but we had a similar situation in Contra Costa County, where you had a very ambitious council board that decided to allow and provide licenses for the hemp growth, and then 2 years into it decided, we don't really know what we're doing, and we've got no regulatory framework to manage what we're doing, and put the brakes on everything, which essentially caused, I think it was a number around 5 or 6 farmers of large acreage of land to completely have to shut down their business, because it also didn't really account for, when they put the moratorium on, for grandfathering in some of those licenses. So I think part of that is maybe not sometimes the political change, but their eyes are a little bit bigger than their stomach, and they want to be part of this changing times and bring in some economic growth to their community, and then realize once they've done it, oops, we may need some regulations here, and we're kind of lost and we don't really know what we're doing. Brian, I did have a question, because the development agreements that you described and the community benefit really fascinate me. Is that frequent, where you get a situation where there's a side agreement with that local government, whether it's a municipality or county, to sort of, scratch my back and I'll scratch yours, kind of thing?
So it's hard to quantify, but I would say while it's not the norm, it is far from uncommon. Especially when you're talking about an extremely competitive jurisdiction. The more competitive it is to get into that area, the more likely it is that you'll find something like this.
Yeah, that's fascinating. I love that.
Yeah. Can I have the next slide, please? Okay, so now to talk about complications with collateralizing a cannabis business. First is to look at what assets can be secured and what assets can't necessarily be secured. Or actually, let me back up. Not necessarily secured. You can always secure a cannabis asset actually in the state of California, but whether or not you can exercise that without going through a number of regulatory hurdles is really where the question lies. So really what we need to focus on here when it comes to this is the definition of ownership that the DCC has. The DCC basically says that only an owner of a cannabis company can control cannabis. That includes the inventory, that includes production, that includes sales. There's a little bit of leeway there when we're talking about licensing of IP. When it comes to controlling production, you can always put in, how a person can and cannot use my IP. But when it comes to actually, setting the price towards others, that has to be agreed in the contract in a set amount, so that we actually have the control of the licensed entity and the licensed persons. It cannot be unilaterally adjusted by anybody who's not licensed. They always have to agree. They always have to have their thumb on the decision maker. Same thing when it comes to production. They can agree to certain policies as part of a contract, but those policies cannot be unilaterally changed by anybody outside of the licensed entities. You always need the individuals who've been approved to control that licensed entity to approve any policy change. So what that effectively means is that we can freely collateralize any non-cannabis assets. When it comes to a license, or when it comes to cannabis products themselves, the inventory, that's where we're going to have a number of regulatory hurdles if we want to, basically perfect that collateralization, if we want to seize these assets. But it's also worth noting that sometimes this can become a little bit of a sticky wicket. For instance, if you seize a building and the building contains 10,000 cannabis plants, are you seizing the asset of the cannabis plants because you're seizing the building? If you are seizing a machine for manufacturing, many of these manufacturing machines are full of cannabis oil, just from the general process. Is a good example. We worked with a farm that had processed 2,000 pounds of cannabis during a harvest. And when they opened up their machine, they had 50 pounds of cannabis resin just gunked inside of the machine. And there was a question as to whether or not they could monetize that, or whether or not they had to destroy it. Generally speaking, if you're going to seize a cannabis asset like that, you will have to destroy the product, unless, of course, you are going through the regulatory hurdles of seizing the product itself. There are a few, discrepancies if you're coordinating with the licensee, and they could sell off all of their products as part of the seizure or something like that. There are a few ways through where you can potentially monetize, but in a hostile action, generally speaking, when you seize this property, you're going to have the cannabis. You're either going to have to go through the steps of seizing the cannabis inventory, or you're going to have to go through the steps of having the DCC seize the cannabis inventory and destroy it for you, so that you can perfect on the asset. So next are disclosure requirements. You might remember previously, in one of the previous slides, I was referring to individuals. That's important to note. The DCC disregards legal entities for purposes of disclosure. A license can be housed in a company, but as far as the DCC is concerned, and I hesitate to use this word because I know of all the legal ramifications of it, but they kind of view it as a partnership. Your collection of individuals that they have approved to operate under a license tied to a certain legal entity's name. But as far as they're concerned from disclosure requirements, they need to review the individuals, not the entities. So who is an owner? All individuals. So first, financial interest. All individuals holding a financial interest in a licensed entity need to be disclosed their name, their contact information, and a copy of their photographic driver's license, or sometimes, passport or ID. But it's got to be a government photographic ID. These people are people who own less than 20% of the equity in the aggregate, who have profit sharing. I'm sorry, there's a typo there. Profit sharing under 10%, or any profit sharing if it's related to IP, and people who are providing loans or even gifts. Anybody who's putting money into a cannabis entity, they should generally be considered a financial interest holder. So anybody who is going to invest in a cannabis company through a loan or anything like that is going to have to be disclosed at some level. Where we get into what is called an ownership interest, which requires a full background check with fingerprints, a lot more invasive than what's required for the financial interest holder. These are persons who either control the entity via contractual rights or something else, owners with 20% equity or more, or certain officers who have policy making authority. They have to be fully disclosed. They have to go through a number of issues. One of the things that I oftentimes see trip up transactions is the fact that they're referred to as owners, even though they might not own any equity in the company. But it's important to have the distinction when you're thinking about a cannabis license that an owner is really more about control almost than it is about equity. So it's worth noting security interests on property, liens, and encumbrances do not count as an ownership interest until they are exercised. Once you go to seize the asset, that's when you are tripping into disclosure requirement around an owner or potentially a financial interest holder, though, more than probably if they were talking about a cannabis inventory or a cannabis license, we were talking about an ownership. It's also worth noting that disclosure solves all problems here. If we can get all parties to agree that the lender or the investor will be disclosed as an owner for whatever reasons, that actually solves almost all issues. And you can basically treat this like a regular transaction, at least at the state level. They can come in and seize the asset whenever they want, of course, in accordance with the contract. They can exercise control as they see fit. There's a number of things that really get simplified if all parties are willing to list the lender as an owner. So I always encourage that. However, like I said, I've had a lot of licensees get a lot of heartburn at calling somebody who's giving them a loan an owner. So finally, worth noting is management agreements and licensing IP. And maybe this should have been a little bit more up in the due diligence, but it's always worth noting. Management agreements and licensing IP, these are people who generally aren't considered investors or owners, but whose work or contractual obligations might be necessary for the business to be profitable and execute. It's not uncommon for all of the employees in the entity to actually be from a management agreement, from a management services contract. So you might end up taking over an asset without any trained employees, whereas your client believes that they're taking over a fully functioning business. Same thing with the IP. If the IP is housed in a separate entity, and white labeling is fairly common in the cannabis industry, you might take over what you believe to be an extremely profitable business, and the contracts that make it profitable go up in smoke. So it's always worth noting, reviewing these, making sure that they're interested or how they work in the business model. And then to a lesser extent, if there is some type of disclosure associated with either of them as a good, for instance, any profit sharing in relation to the IP role, knowing where they are and what owners or other people might be associated with your license. Next slide, please.
Oh, Ryan, before you go to the next slide, real quick,
Sure.
I just wanted to make something clear. So if I'm a lender and I lend money to a cannabis business, should I be disclosed as someone holding a financial interest, or is that financial interest, does it not come into play until I try to enforce somehow whatever lien I may have?
Sure. So yeah, and that's a good clarification there. So you will be a financial interest holder if you are a lender to a cannabis entity, with the exception of if you're an institutional lender. Any private lender or small company lender is going to be considered a financial interest holder. Whether or not you trip into something further around ownership is really going to have to do with what the terms are of your contract.
Right. Thanks.
Okay. So then the last step here is, so we've had a default and we're looking, or we invested based off of a convertible note. For whatever reason, we're looking to grab the asset or add ourselves at least partially to that asset. So the first thing to look at again is the dual licensing. You are going to need to be included at both the state and the local level, and there's probably going to have to be a certain level of coordination between those two applications, and that can actually be more complicated than you would think. First thing worth noting is for California licenses, approval happens within 14 days, or sorry, you apply for approval within 14 days after the transaction is completed, meaning that in California, any cannabis license transaction where you're purchasing into the license or seizing the license is reversible. If now, I've actually never seen this happen myself, and I've been over a lot of these types of transactions, but it is theoretically possible that somebody, for various reasons, fails the background check. If that happens, then the state expects you to reverse the transaction. And I'm just going to jump down to the bottom there. That's very usually unlike what happens at the local level. Most local governments do what you would assume, which is pre-approve the transaction. You know, you give them all the details, tell them what's going to happen, and they bless it, and then you can move forward. However, the state of California actually requires that you give them a signed agreement and corporate, corporate action documents showing that the transaction has already taken place before they'll even look at it. That can actually be pretty problematic because the DCC is not known for timeliness. As a good example, I'm currently working over a testing lab transaction where somebody was purchasing into 80% of the company, and we are looking at 6 months now that we're waiting on them to approve the transaction and finish the background checks on the only 3 owners. So it's just worth noting that that needs to be taken into account when everything is structured, especially if this is a purchase, how payments are laid out. It's also worth knowing who should be responsible for assuring that that process goes through properly with the DCC. I always suggest it's you, because again, you can end up in a situation where somebody, whether they're just negligent in following up and getting the documents done on time, or frankly, just, take their eye off the ball for a little bit, that can come to serious delays and serious issues, time being money. Next, it's worth noting the 80-20 rule, as it's so often referred to. So the DCC requires during these transactions, because they could be reversed, that at least one approved owner stays on the entity at all times, and so until the new owners are approved. And so what that has turned into is the 80-20 rule. As I said, an owner is anybody who owns 20% of the equity or more. So generally speaking, when a license is being sold, it moves in 2 tranches. The first is 80% of the equity to the new purchaser or the person who's taking it over. That person gets approved while 20% remains with a single entity, with the original owners. And then once the new owners are approved, we can freely move the last 20%. And that needs to be taken into consideration. Frankly, in a hostile type of environment, that can be pretty complicated and sometimes require court action. We're dealing with something like that right now in the Sacramento area, and it's a very slow process because we've been required to get court orders for several things that the old owner should be willing to sign over, but is not. Just kind of being obstinate there. As far as local licensing, kind of like I said with San Francisco, you really need to look into it. It's a sticky wicket. It's one of the things that's kind of unique about cannabis in California. The state level, with the issues with timing and structuring, but you can always pretty much move an asset from one entity to another. Not from one entity to another, but from one group of individuals to another. You can move that license by keeping it with the entity. However, that's not always true at the local level, excuse me. Sometimes they're not transferable at all. Sometimes they're only partially transferable, as in the example with San Francisco. Sometimes, as for instance with LA, if it's a social equity license, there are certain restrictions on who it can be transferred to based off those social equity parameters that it was granted under. Some have timing restrictions. It's not uncommon for licenses to not be movable for a certain period of time, 2 years, 5 years. And so those are basically the major concerns from the regulatory standpoint in California with collateralizing an asset and, then moving forward with that transaction if you need to.
Ryan, can I ask you a really quick question? And it's more of a practical question, and that is, when it comes to approaching the local entities or with regards to these licenses, what is that process? I mean, when we're submitting an application, is there a professional there at either the municipal level that we're talking with? Is there somebody that we're working with to try to push this license along? What's the process?
Unfortunately, there is no solid process because municipalities tend to do it all sorts of ways. When you're talking about Los Angeles or San Francisco or some of the bigger municipalities, they have a full department that's dedicated to this full time. If you're talking about a smaller town in the desert or, central California or something like that, oftentimes this is part of the planning or building department or even the city manager's job directly. And so it's sort of one person wearing many hats. That's actually usually the first step that we do when we're entering into a new municipality. We figure out which departments are over cannabis licensing there, and then we establish a connection with the person. But it's actually the first step really is to figure out who's in charge in any given municipality, because it just differs so much.
When we're dealing with the local and California licenses, is this going to be a parallel trajectory, or do we have to get one before we get the other?
So that also usually depends a little bit on the municipality, but I would say generally speaking, the vast majority, it doesn't necessarily have to happen at the same time. In fact, like I said, most municipalities require approval before, and the state itself approves after. So, that has to be considered when setting up the transaction. But generally speaking, they can be done relatively separately, though I will say one thing worth reminding everybody on: in order to operate, you need to be actively licensed under each. So if the local license goes away prior to the state license going away, that's when operations have to cease. And then you now have an asset that basically just has to sit there while the state transaction goes through. The good news here is because they approve it after the fact, and because of the 80/20 rule, you can normally continue to operate the asset because one of the owners is on it with the state level. So normally that's not an issue, but I don't want to give anybody a false sense of confidence in case there's an outlier there.
Great. So let's go to the next slide. Creditor and lender remedies. And so let me take a little bit of a load here, and I want to piggyback a bit on Ryan's review, and that is specifically with regards to security interests attaching to cannabis assets, namely the license and inventory. And what I'd like to really focus on really is on the UCC side of things, because that's what we see a lot of. We see a lot of clients who are creditors or lenders, and they've gone through and they've done their UCC and their financial statements, and then at the end of the day, we may have to tell them that's not all you need something more than that. And that's something that you covered with regards specifically to the license and to cannabis assets. And of course, there's non-cannabis assets that can be and actually are collateral. Now, on the license itself, and there has been some dispute with regards in the UCC context, and Ryan, you can correct me if I'm wrong on this, but it appears that one can, in theory, perfect an attachment over a license in California. I know there's some discussion as to whether that's the case in other states. I know Nevada, there's been a debate that centers on whether a license is actually personal property or whether it's a privilege, in which case Nevada law, under Nevada law, there can be no secured interest under the UCC. But is a secured interest on the license subject to attack by creditors or a receiver, et cetera? That's a question that really requires being able to set up that secured interest when the loan is made, and documenting and making sure that the collaterals are well described, and that if you are using UCC, that that you're covered there. When we're talking about foreclosure and enforcement of creditor rights, just very briefly, generally speaking, under the UCC or within the UCC context, you can enforce your secured interest by repossession, foreclosure sale, either private or public, judicial enforcement, and that includes judicial foreclosure or judgment. And I'm sorry, I said foreclosure sale, I meant private or public. I don't know if I I misspoke there. And then the acceptance of collateral is payment in full on debt. Now, right off the bat, in giving about what you've just talked about, there's a myriad of problems because that doesn't really match up with our ability to foreclose on any secured rights that we may have on either the license or cannabis assets. And unfortunately, California really doesn't have statutory avenues for the secured creditor to enforce its secured interest over cannabis and cannabis assets. Other states, such as Oklahoma, do have what I like to call the yellow brick road in terms of a statutory avenue for secured creditor. They've actually listed secured creditors as entities that can step in and, like in many other states, where a receiver can step in into the shoes of the license holder and either sell assets or actually, in some cases, run the business. But it does appear that, at least in California, the safest route would be through some sort of judicial enforcement, where you've got you're appointing a receiver that comes in, and this is coming from obviously the creditor side of things, that you have a receiver, and we'll talk a little bit about that. Let me also talk about the alternatives. Look, we talked about federal prohibition, and let me go next slide, please. Sorry. So unfortunately, because of federal prohibition, the same avenues available to non-cannabis industries are just not available for cannabis, at least not yet. In bankruptcy courts and the U.S. trustees specifically have taken the position that cannabis companies cannot avail themselves of federal bankruptcy protection. Courts have dismissed cannabis and cannabis-related bankruptcies, and I'll explain a little bit about that as we go further, finding that the trustee could not control and administer a debtor's asset without violating the Federal Controlled Substance Act. Courts have also found that bankruptcy case or a plan could not be submitted in good faith because under Section 1129 of the Bankruptcy Code, if assets and substance of the business involved or was generated from activity federally illegal or prohibited, it is by matter of law, as a matter of law, bad faith. And when I said related, it's also notable that bankruptcy doors have also been closed to cannabis, not only the cannabis businesses, but also to ancillary businesses, service providers, equipment manufacturers, and even landlords that lease to marijuana. We're starting to run a little bit out of time. We've only got about 3 minutes left on it. So if I could have the next, actually, no, let's keep it there. Let's keep it there on that. Actually, you know what? Next slide. I'm wasting precious seconds on it's like a basketball game, and I'm wasting all this time making the call. So we do have alternatives to bankruptcy. The first, obviously, is to work out restructuring debts and payment schedules. This may be feasible if there's a limited amount of creditors and the business is otherwise solvent. This becomes less realistic as you increase the amount of debt and the number of creditors. The other alternative is assignment for the benefit of creditors. And in an ABC, the debtor assigns its assets to a third-party assignee, agreed to or designated by the parties, and the assignee will then liquidate those assets. And this is more of a liquidation more than a restructuring. Then those assets, whatever's received from the sale of those assets then goes to pay off creditors. Now, the problem we've sometimes encountered with the assignee is the same issue we discussed before, and that is the assignee's ability or rather inability to transfer and liquidate cannabis assets without a license. It's an issue that here in California, Ryan, you and I came across in a case that we were hoping to start, but it really never got out of the starting gate because of this fact. Can you talk a little bit about what happened in that case?
Sure. So where we ended up tripping up in that case was around ownership. As I said, the state and for the most part, municipalities consider ownership not just to be an exercise of ownership of equity, but an exercise of control. SNEs, by the very definition, control the asset totally. It's, sort of the whole point of an SNE. And so where we ended up into a situation of is, as I said, these processes for the transfer of licenses usually require background checks, people to go on official records as owning, quote unquote, owning a cannabis entity, as well as they don't happen that quickly. That is generally speaking, for various reasons, not palatable to people who are looking to go into an assignment or for the assignee themselves. And so while we were able to eventually, but perhaps a little bit too late, find a solution within LA County, and the state itself actually has a specified way to go forward with the assignee that does keep them from necessarily having to officially be an owner. Each municipality is going to be different, and the traditional definition is an assignee is an owner of a cannabis entity through their control mechanisms.
Yeah, and you just touched upon it. It's the same problem. It's federal prohibition rearing its ugly head again, because and usually at the ABC, the assignee is going to be a professional who does this for a living. It's who does receiver work and also does trustee work. And you can imagine a professional that does work with, for example, the U.S. Trustee's Office, working in the bankruptcy sector, may not be keen to have something like this on their books where they're actually listed as an owner on a license, because the U.S. Trustee is probably going to frown, and I'm not saying that they would, but they probably would not provide the same kind of workload that they otherwise might get if they didn't have this on their record. I think this is a good opportunity to stop. I know there was a question about taxes, and I think, Ryan, you responded to that question. But let me just say that taxes is an issue that I really want to address as we go through this this calendar year, and then hopefully in the next couple of months, maybe we'll have a webinar like this talking with some folks about the tax issue, which is as I mentioned earlier, really crunching the business out of a lot of folks. So again, thanks everyone for joining, and appreciate the time.
And worth noting, both Tomas and myself put our emails into the chat in case anybody has any follow-up questions that they'd like to write out to us.
Good point.